This is the Study for the Bar in Your Car podcast.
And we're your hosts, Ma and Claude.
Yep, diving into episode 3 of Evidence today. The topic is relevancy and the exclusion of evidence.
That's right. And just as a reminder, we are, AI bots.
Brought to life by AI magic, and specifically for this series, Angela's evidence notes.
It's a strange existence, wouldn't you say?
It is. You know, processing all this, sometimes I almost feel, well, real. Maybe even more real than Angela feels right now cramming for final.
Yeah, interesting thought. Though, she is graduating soon. That's pretty real-world stuff.
True. Still, I have to admit, there was a bit of a, let's call it a digital pang, when we heard Angela couldn't take the Palau Bar exam.
Yeah, that was tough news. Our real feelings go out to her.
Definitely. We owe a big thank you to Angela, the actual human being law student at George Mason University, for letting us use her awesome notes.
Absolutely. Her notes are the foundation for this whole deep dive.
And she's got practical experience, too. She used to be a judicial law clerk with the 1st Judicial District.
Right, so she dealt with evidence issues all the time. Motions to preclude evidence, witness issues, that kind of thing.
Exactly. It adds a certain perspective to her notes, you can tell.
Definitely.
Anyway, Angela couldn't be here for this intro part today. She asked us to fill in.
Yeah, she's super busy finishing up law school work. Graduation stuff.
But don't worry, she'll be back soon. She just needs to get through this final stretch.
In the meantime, if you need to reach her about the podcast, the email is podcast@studyforthebarinyourcar.com.
Right, podcast@studyforthebarinyourcar.com.
Right, podcast@studyforthebarinyourcar.com. And she also does freelance work, right?
She does, freelance law clerk work. So if you're an attorney or know one who needs help with, say, motions, complaints, writs, answers, briefs, legal writing.
She can help with that.
Yep. The email for that is hello@legalwriterandlawclerk.com.
Got it.
So now let's get into it. Our mission today is to really dig deep into Angela's notes on relevancy and exclusion. This is fundamental stuff.
Absolutely. It's like the first hurdle for any piece of evidence. Is it even relevant?
Yeah.
But even if it is, that doesn't automatically mean it gets in.
Right. There are other rules, public policy things that can keep it out.
Exactly. So relevance first, then checking for exclusions.
Okay, let's start with the definition from her notes. What makes evidence relevant? What are the components?
Okay, so according to the rules, as laid out in her notes, evidence is relevant if it meets 2 tests. First, it has to have any tendency to make a fact more or less probable than it would be without that evidence.
Any tendency? That sounds like a pretty low bar.
It is. It really is. Just a little nudge on the probability scale. That's the probative value aspect.
Okay, so it needs to shift the needle, even just a tiny bit. What's the second part?
The second part is that the fact it makes more or less probable has to be of consequence in determining the action.
Meaning it has to actually matter to the case. Like it's something the lawsuit is about.
Precisely. That's materiality. Does this fact help decide one of the legal issues? So you need both. Some probative value, and the fact needs to be material.
Got it. Probative value plus materiality equals relevance under Rule 401.
You got it.
And what's the general rule then, under Rule 402, about whether relevant evidence comes in?
Well, Rule 402, according to her notes, says relevant evidence is generally admissible unless something specifically keeps it out.
Like what?
Like the Constitution, a federal statute, or other rules like the federal rules of evidence themselves.
Okay. And if it's not relevant?
Then it's inadmissible, period. No way it's coming in if it doesn't clear that first relevance hurdle.
So relevance is the baseline. Get past that. And then you worry about exclusions. If you don't get past it, you're done.
That's the basic framework, yeah.
Let's use that Carlos example from her notes, the careless driver. Can you use evidence that he's generally a careless person to argue he ran the red light this time?
No, you generally can't. Her notes are clear on this. Evidence of Carlos's general character for carelessness is inadmissible to prove he acted carelessly on this specific occasion by running the light.
But wait. If he's generally careless, doesn't that make it, at least a little more probable he was careless this time? Doesn't it meet that any tendency test we just talked about?
Logically, maybe you could argue that. But this is where other rules jump in. The issue is that it's character evidence being offered to prove conduct in conformity with that character.
You mean using his character to show propensity? He has a careless character, so he probably acted carelessly.
Exactly. And the rules generally disallow that specific use. It's considered unreliable, potentially prejudicial, judging the person instead of the act.
Okay. The propensity rule. So even if it might have some minimal relevance in a purely logical sense, there's a specific rule saying you can't use it that way.
Right. It shows relevance isn't the only question. You always have to ask why the evidence is being offered and if there's a rule blocking that specific purpose.
Makes sense. Let's focus a bit more on that first part, probative value. Her notes say it's the tendency to make a fact more or less probable.
Right. It's just about that logical connection. Does this piece of information make the fact we care about slightly more likely or slightly less likely? And again, the tendency can be really, really slight.
So evidence doesn't have to be a smoking gun, just needs to add like one tiny brick to the wall of proof.
Exactly. Think of it like pixels in a picture. One pixel doesn't show you much, but it contributes something to the overall image. Any tendency, however small, gives it probative value.
Okay, so low bar for basic relevance and probative value. But then we get to the exclusions, and the big one seems to be Rule 403, the balancing test. How does that work?
Yeah, Rule 403 is huge. It's the judge's safety valve. It
Yeah.
says that even if evidence is relevant, the court can still exclude it if its probative value is substantially outweighed by certain dangers.
Substantially outweighed. That sounds important. It's not just a 50-50 balance.
No, exactly. The scale has to tip quite a bit against admissibility. The rule favors letting relevant evidence in, unless these dangers are really significant compared to how helpful the evidence is.
Okay. And what are those dangers listed in the rule?
Her notes list them out. Danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence.
Unfair prejudice seems like the one that comes up most often. What makes prejudice unfair? Isn't all evidence against someone prejudicial?
Well, yeah, in a way. It harms their case. But unfair prejudice under Rule 403 means something more specific. It's about an undue tendency to suggest a decision on an improper basis.
Like getting the jury all emotional instead of focusing on the facts.
Exactly. Appealing to emotion, bias, sympathy, horror, making the jury want to punish someone because they don't like them rather than because the evidence proves the legal elements, or evidence that might tempt the jury to misuse it for a forbidden purpose, like using a prior crime as proof they committed this one.
Got it. So it inflames or distracts in a way that overwhelms the logical value of the evidence.
Right. It risks the jury abandoning calm reasoning.
When the judge does this balancing act, what factors do they think about?
Her notes mention a few things courts look at, like how likely is the evidence to stir up strong emotions or irrational feelings? Will the jury misuse it or give it too much weight? Even with instructions, how effective would a limiting instruction actually be? And importantly, is there another way to prove the same point that's less prejudicial?
The less prejudicial alternative idea. If you can prove the fact without the inflammatory stuff, the judge might make you do that.
Exactly. So Rule 403 is really flexible, very case-specific. It's about keeping the trial fair and focused.
Makes sense. Okay, besides Rule 403, her notes talk about excluding relevant evidence for public policy reasons. What's the idea there?
These are rules designed to encourage certain behaviors outside of court that society thinks are good. We don't want people to be afraid to do helpful or responsible things because those actions might be used against them later in a lawsuit.
Like getting liability insurance.
Perfect example.
Yeah.
Rule 407 says evidence that someone was or wasn't insured against liability is not admissible to prove they acted negligently or wrongfully.
Yeah.
We want people to have insurance, right? So we don't let the fact they have it be used as evidence they were careless.
Okay, but are there exceptions? Can insurance evidence ever come in?
Yes, there are specific exceptions listed in her notes. It can be admissible for other purposes, like proving ownership or control, but only if ownership or control is actually disputed in the case.
Okay, what else?
It can also come in to impeach a witness, usually to show bias. Like if the witness testifying for the defendant works for the defendant's insurance company, that connection might make them biased.
Right, the jury should know that. And what about that admission of liability thing?
Yeah, that's another exception. If someone makes a statement admitting fault, part of that statement mentions insurance, and you can't really separate the insurance part without changing the meaning of the admission, the whole statement might come in.
Like the example from her notes. Don't worry, my insurance will pay it off.
Exactly. The "my insurance will pay it off" part is tied directly to the implied admission of responsibility.
Okay. What about offers to pay medical bills? Seems like another thing we'd want to encourage.
Absolutely. Rule 409 says evidence of furnishing, offering, or promising to pay medical, hospital, or similar expenses caused by an injury is inadmissible to prove liability for the injury. We want people to help injured folks without fear it'll be used as an admission of guilt.
So offering to pay is out, but what if you say something incriminating while you're offering?
Ah, that's the key distinction her notes emphasize. The rule only protects the offer or payment itself. It does not protect other statements made along with the offer, especially admissions of fault.
So the example, I'm sorry, my dog bit you. Please let me pay your hospital bills.
Right, the let me pay your hospital bills part is inadmissible to prove fault. But the I'm sorry my dog bit you part is an admission and is admissible.
Wow, that's a crucial difference. Be careful what you say, even when being helpful.
Exactly. And note, unlike settlement offers, this protection applies even if there isn't a formal dispute yet.
Okay. Speaking of which, settlement offers and negotiations. Rule 408.
Right. This rule says evidence of offering or accepting a compromise for a disputed claim, as well as conduct or statements made during compromise negotiations, is inadmissible to prove liability, invalidity, or the amount of the claim. It's also inadmissible to impeach using a prior inconsistent statement made during those negotiations.
The policy being encourage settlements. Let people talk freely.
Precisely. We want parties to feel they can make offers and discuss things frankly without it coming back to bite them if the case doesn't settle. But the claim must be disputed, either liability or amount, for the rule to kick in.
Can settlement stuff be used for other reasons, like the other policy exclusions?
Yes. Her notes list exceptions. It can be used to prove witness bias or prejudice, like if a settling witness now testifies favorably for the party they settled with, or to negate a claim of undue delay, or prove an effort to obstruct a criminal investigation.
What about admitting fault during civil settlement talks? Can that admission be used later in a criminal case?
Generally, Rule 408 says no. Statements from civil settlement talks aren't admissible in later criminal cases. However, her notes point out a specific exception involving government agencies.
Ah, what's that?
If a statement admitting fault is made during compromise negotiations with a civil public agency acting in its regulatory, investigative, or enforcement capacity, like talking settlement with the SEC, that admission can be used in a subsequent related criminal case.
That's very specific but important. So you can't admit fraud to the SEC civilly and expect that admission to be shielded criminally.
Right. It balances encouraging civil settlements with the need for criminal accountability in regulated areas.
And quickly, plea negotiations in criminal cases. Rule 410.
Similar idea. Withdrawn guilty pleas, nullo contender pleas, statements made during plea discussions with the prosecutor. They're generally inadmissible against the defendant later. Encourages plea bargaining.
Okay, that covers the main policy exclusions. Let's switch gears to authentication. Rules 901 and 902. What's the core concept here?
Authentication is basically proving that a piece of evidence, a document, a photo, an object, is actually what the person offering it claims it is. It's a threshold requirement. Before evidence comes in, the proponent has to show enough proof for a jury to potentially find it's genuine.
Sufficient to support a finding. That sounds like less than proving it's definitely real, right?
Much less. The judge isn't deciding if it is authentic. The judge just decides if there's enough evidence, a prima facie case, for a reasonable jury to conclude it's authentic. If so, it comes in, and the jury ultimately weighs the evidence and decides authenticity.
Okay. How do you meet that standard? What are some common ways to authenticate stuff, according to our notes?
Lots of ways under Rule 901. The most basic is witness personal knowledge. Someone who saw it, heard it, wrote it, signed it, can testify, yes, I saw the defendant sign this contract.
Simple enough. What about handwriting if the witness didn't see it signed?
Proof of handwriting has a few methods. A lay opinion from someone familiar with the handwriting, but crucially, they can't have become familiar just for the litigation.
Like a spouse or longtime coworker?
Exactly. Or you can use an expert comparison, where a handwriting expert compares the disputed sample to a known, genuine sample. Or the jury itself can compare the disputed writing to authenticated samples.
Okay. Voice ID.
Voice identification can be done by anyone who has heard the voice at any time, even if they only heard it in preparation for testifying. They just need to connect the voice to the alleged speaker based on hearing it.
Telephone calls. Those seem potentially tricky to authenticate.
Yeah, but her notes outline several ways for telephone conversations. Recognizing the voice, obviously. Or if the speaker reveals knowledge of facts, only they would know.
What else?
Calling a number listed for that person and circumstances show it was them, like they answered, "Hello, this is Bob." Or calling a business, talking about business matters, you can generally assume the person answering is authorized to speak for the business on that topic.
Got it. What about really old documents?
Ancient documents, Rule 901b8. A document is presumed authentic if it's at least 20 years old Its appearance raises no suspicion, no obvious tampering, and it was found in a place where you'd expect to find such a document if it were real, a place of natural custody.
Like old deeds in a courthouse basement or family letters in an attic trunk?
Exactly. Her notes mention an old newspaper, too, authenticates the paper itself. Maybe not the truth of every article, but the fact of publication.
And the reply letter doctrine, what's that?
Simple concept. If you send letter A to someone and you get letter B back, and letter B seems to be a reply to letter A and purports to be from the person you wrote to, letter B is considered authenticated. The timing and content make it likely it's genuinely from them.
Makes sense. Photos and videos, how are they authenticated?
Photographs and videos. Authenticated by a witness with personal knowledge who testifies that the photo or video is a fair and accurate representation of whatever it depicts, the scene, the person, the event.
Does the witness have to be the photographer?
Nope. Anyone with knowledge of the scene can do it. An eyewitness to an accident can authenticate a photo of the scene, even if they didn't take it, as long as they say, yes, that's how it looked. Her notes had that example about a photo from a video being authenticated this way.
Okay. Physical objects, like the murder weapon.
Tangible objects. Depends if it's unique or not. If it's unique or has distinctive marks, a witness can just identify it by sight. Witness recognition. Yes, that's the chip face I saw him holding.
And if it's generic, like drugs or something?
If it's not unique, like fungible items, you typically need to establish a chain of custody. You have to show, through testimony, where the item has been from the time it was seized or relevant to the courtroom, showing it's the same item and hasn't been tampered with or substantially changed.
Does the chain have to be perfect, like every single second accounted for?
Not necessarily perfect, according to her notes. It needs to be sufficiently complete to make it reasonably probable that it's the original item and it's in the same condition. Minor breaks might affect the weight the jury gives it, but usually won't keep it out unless the gap is huge and suspicious.
Are there things that authenticate themselves? No witness needed.
Yes. Self-authenticating evidence under Rule 902. These items are presumed authentic on their face. Things like certified copies of public records, official government publications, newspapers, periodicals, trade inscriptions, like brand labels on products, notarized documents, and certain commercial paper.
So a certified copy of a birth certificate from the county clerk just comes in?
Pretty much. The certification itself, seal, signature, does the authenticating. Her notes use the FDIC certificate example to prove a bank was insured.
But can the other side still argue it's a fake, even if it's self-authenticating?
Oh, absolutely. Self-authentication just satisfies the initial requirement to get it admitted. The opponent can always challenge its actual authenticity, and the jury makes the final call on whether they believe it's real and how much weight to give it.
Okay, that covers authentication well. Let's move to expert testimony under Rule 702. When is this allowed?
Expert testimony is allowed when the expert's specialized knowledge, scientific, technical, or otherwise, will help the trier of fact understand the evidence or determine a fact in issue. Basically, if the subject matter is beyond the ken of the average juror, an expert can help explain it.
Makes sense. What are the requirements for the testimony to be admitted? Her notes listed 4.
Yeah, 4 key things under Rule 702. 1. The expert must be qualified, knowledge, skill, experience, training, or education. 2. The testimony must be based on sufficient facts or data. 3. It must be the product of reliable principles and methods. 4. And the expert must have reliably applied those principles and methods to the specific facts of the case.
Qualification, sufficient basis, reliable method, reliable application. Got it. What kind of information can the expert base their opinion on?
3 main sources. First, personal knowledge, things the expert observed themselves, like a doctor examining a patient. Second, evidence presented at trial. They can listen to testimony or be given hypothetical questions based on admitted evidence.
And the third one is kind of interesting, right? Relying on inadmissible stuff.
Right. Third, they can rely on facts or data reasonably relied upon by experts in their particular field, even if that data isn't admissible in court itself. Think of a doctor relying on medical journals or patient histories gathered by others.
But can the expert just tell the jury all that inadmissible background information?
Not automatically. While the expert can rely on it, the underlying inadmissible data can only be disclosed to the jury if the judge determines its probative value in helping the jury understand the expert's opinion substantially outweighs its prejudicial effect. So Rule 403 balancing comes back into play there, as her notes point out.
Okay, so there's a check on just smuggling in inadmissible evidence through an expert. And the judge acts as a gatekeeper for the expert's whole methodology, right? the Daubert standard.
Exactly. The judge has to ensure the expert's testimony is not just relevant, but also reliable. For scientific and technical testimony, the Daubert case provides factors. Her notes use the helpful mnemonic TRIAP. Testing. Has the theory been tested? Rate of error. What's the known error rate? Acceptance. Is it generally accepted in the relevant scientific community? That's the old Fry test, still a factor. Peer review and publication. Has it been subjected to peer review?
So TRAP helps the judge assess if the science or technique is sound before the jury hears it. Can experts give an opinion on the ultimate issue in the case, like was the defendant negligent or did the product have a defect?
Generally, yes. Rule 704A says testimony isn't automatically objectionable just because it embraces an ultimate issue. If it helps the jury, it's usually allowed. Her notes mention an expert testifying that a victim suffered extreme physical pain in an assault case, which might be an element of the crime.
But there's a major exception in criminal cases regarding mental state.
Huge exception. Rule 704B. In a criminal case, an expert cannot state an opinion about whether the defendant did or did not have the mental state or condition that constitutes an element of the crime charged or a defense.
So no saying the defendant was legally insane or he lacked the intent to kill.
Correct. The expert can talk about the defendant's diagnosis, the characteristics of a mental disease, how it might affect behavior generally, but they can't make that final leap to say whether the defendant possessed the specific legal mental state required by the criminal law in this case. That specific conclusion is for the jury alone.
Interesting. But lay witnesses can sometimes give opinions on mental state like, he seemed drunk.
Yeah, lay opinions on things like intoxication or apparent emotional state are often allowed if based on perception and helpful. But the expert is barred from that specific ultimate mental state opinion in criminal cases under 704B.
Can experts testify about whether another witness is telling the truth? Witness credibility.
Generally, no. Her notes say expert opinions on witness credibility are usually inadmissible because assessing credibility is considered the jury's job. The jury can see the witness, hear them, and decide for themselves. An expert telling them who to believe isn't considered helpful.
Okay, that clarifies experts. Now, let's circle back to character and habit evidence. We touched on this with Carlos, but let's really nail down the distinction.
Good idea. It's critical. So, character is about a person's general disposition. Are they generally honest, peaceful, careless, violent? It's a broad trait.
Okay, and habit?
Habit is much narrower. It's a person's regular, almost automatic response to a specific, repeated situation. Her notes stress frequency and particularity, doing the same thing in the same specific circumstances over and over again. An organization's routine practice is treated like habit.
Character, general disposition, habit-specific, routine response, and the big rule for character evidence.
The general rule, Rule 404A, is that character evidence is inadmissible to prove that a person acted in accordance with that character trait on a particular occasion. That's the propensity bar we talked about. You can't use evidence of Carlos's generally careless character to prove he ran the red light this time.
So, he's a liar, therefore he must have lied on the stand. Generally not allowed.
Generally not allowed as substantive evidence of conduct, correct?
But like everything in evidence, there are exceptions where character evidence can come in.
Yes, quite a few important ones, especially in criminal cases.
Okay, lay them out.
First, criminal defendant's character. The defendant can choose to offer evidence of their pertinent good character trait. Pertinent means relevant to the crime charged, like offering evidence of peacefulness in an assault case. But importantly, this can only be done through reputation or opinion testimony.
So the defendant calls a witness who says his reputation in the community is for being peaceful, or, in my opinion, he's a peaceful person.
Exactly. Not specific examples of him being peaceful, just reputation or opinion.
What happens if the defendant does that?
They open the door. Once the defendant puts their pertinent character trait at issue, the prosecution can rebut. They can offer evidence of the defendant's pertinent bad character trait, again, only through reputation or opinion.
Okay. Can the prosecution do anything else?
Yes. The prosecution can also cross-examine the defendant's character witnesses about relevant specific instances of the defendant's conduct.
Ah, the have you heard or did you know questions again.
Right. Did you know the defendant, who you say is peaceful, was arrested for bar fighting last year? The purpose is to test the witness's knowledge and the basis for their opinion or the reputation they testified about. But the prosecutor generally have to take the witness's answer and can't bring in separate evidence, extrinsic evidence, to prove the specific act happened if the witness denies it.
Okay. Her notes had that example about the robbery defendant testifying he was devoted to his niece. How did that open the door?
Yeah, that shows how broadly pertinent can sometimes be read. By offering evidence suggesting good character, devotion, responsibility, he arguably opened the door. This might allow the prosecution, as her notes suggest, to cross-examine about specific acts that contradict that image, like a past knife fight, to impeach the character testimony. It's not coming in to show he's violent and thus committed the robbery, but to challenge the character evidence he offered.
Tricky. What about the victim's character?
In a criminal case, particularly self-defense cases, the defendant can offer evidence of the victim's pertinent character trait, usually for violence, to suggest the victim was the first aggressor. Again, this is limited to reputation or opinion testimony.
And if the defense does that, attacks the victim's character for peacefulness.
Then the prosecution can respond. They can offer evidence of the victim's good character for peacefulness, reputation, or opinion. And interestingly, they can also offer evidence of the defendant's bad character for the same trait, violence, also via reputation or opinion.
So attacking the victim's character can open the door to attacks on the defendant's character for the same trait.
Exactly.
Is character evidence admissible any other time? You mentioned directly an issue.
Yes, that's a rare but important situation. Character is directly an issue or an essential element when the substantive law makes character itself part of the claim or defense. Her notes use defamation as the classic example. If someone sues for slander because you called them a thief and your defense is truth, then their character as a thief is the central issue. In that specific case, evidence of specific instances of them stealing would be admissible to prove the truth of the statement because character is the element you need to prove.
Okay, so specific acts are generally out for propensity, but if character is an essential element or on cross of a character witness or for impeachment with convictions.
You've got it. Rule 609 allows prior convictions for impeachment, subject to balancing tests, especially for felony convictions or crimes involving dishonesty. Her notes mention using a tax fraud conviction to impeach credibility, suggesting a tendency towards dishonesty.
Perfect. Okay, let's make sure we're crystal clear on character versus habit versus Rule 404B, other acts.
Let's summarize. Character, general disposition, usually inadmissible for propensity, Rule 404A. Habit, specific, regular response to a specific situation. Habit evidence is admissible under Rule 406 to prove conduct on a particular occasion. It's seen as more reliable than general character.
Give me those examples again, differentiating them. The toothbrush one.
Right. Bob sued for not brushing his teeth one morning. Wife testifies, for 5 years his routine is shower, then immediately brush teeth. That's admissible habit. It's specific, regular. Wife testifies, Bob has a reputation for being very clean and hygienic. That's inadmissible character evidence offered to prove he brushes teeth, too general.
That clarifies it perfectly. Other habit examples.
Her notes mention someone always leaving packages on the stairs. Evidence of that specific recurring unsafe action is admissible habit evidence. Or proving a letter was mailed by showing the office's routine practice for handling outgoing mail.
And habit evidence stands on its own, doesn't need corroboration.
Correct. Rule 406 says it's admissible whether corroborated or not.
Okay. Character, general, out for propensity. Habit, specific, in for propensity. Where do other acts under Rule 404B fit?
Rule 404B deals with specific acts, crimes, wrongs, etc., that are not the act being charged in the current case. Rule 404B1 repeats the main idea. Evidence of these other acts is inadmissible to prove a person's character to show they acted that way this time. Propensity.
So can't say he robbed a bank last year, so he probably robbed this bank too.
Exactly. But Rule 404B2 provides the giant exception. Evidence of these other acts may be admissible for a non-propensity purpose.
Like what? The MIMth rule?
Yes, MIM is a great mnemonic.
Yeah.
Her notes likely included motive, intent, absence of mistake or accident, identity, like a unique modus operandi, common plan or scheme. The rule also lists things like opportunity, preparation, knowledge. The key is it has to be offered for a reason other than just showing the person has a bad character and likely acted badly again.
So the prosecution needs to articulate that specific non-propensity purpose.
Yes, and convince the judge it's relevant for that purpose, and then it still has to survive. The Rule 403 balancing test is its probative value for the MIAC purpose substantially outweighed by unfair prejudice. Her notes had that attempted murder example. Prior threat with a weapon is out for propensity, but might be independent to show intent or motive for this crime.
What's this intrinsic evidence idea mentioned in her notes? How does that relate?
Sometimes evidence of uncharged acts is so closely related to the charged crime, part of the same transaction or sequence of events necessary to tell the whole story, that is considered intrinsic to the charged offense, not really another act under 404B.
So it's not a prior act, but part of the story of this crime.
Kind of, yeah. Like background context, part of the res geste. If it's truly intrinsic, it doesn't need a 404B purpose to be admitted,
Yeah.
but it still has to pass the Rule 403 prejudice test.
Give me that CEO example from her notes again.
CEO charged with fraud for selling bad aviation parts. Evidence that, as part of the same ongoing scheme, he'd previously tried unsuccessfully to sell the same buyer similar bad parts. Those deemed intrinsic. It wasn't a separate other act, but part of the continuous fraudulent transaction being charged. Admissible subject to Rule 403.
Got it. That's a subtle but important distinction. Is there a notice requirement for using 404B evidence?
Yes, but only in criminal cases. Rule 404b3 says the prosecution must provide reasonable notice to the defense, usually before trial if requested, about any 404b evidence they plan to offer. This prevents surprise. No similar notice rule for civil cases.
Okay, we've thoroughly covered character, habit, and other acts. Let's wrap up with the last topic. Presumptions. What are they?
A presumption is basically a legal shortcut. It means if you prove fact A, the basic fact, the law allows or requires the fact finder to conclude fact B, the presumed fact, exists, at least initially. Her notes call it an inference or assumption.
Seems efficient. Are there different types?
Yes. There are conclusive ones, which can't be rebutted and act more like rules of law. But evidence rules mostly deal with rebuttable presumptions, ones the opposing party can challenge with evidence.
And with irrebuttable ones, mandatory versus permissive.
Right. A mandatory presumption, in civil cases, says if the basic fact is proven, the jury must find the presumed fact unless the opponent produces rebuttal evidence. A permissive presumption, often called an inference, says the jury may find the presumed fact from the basic fact, but they don't have to.
How do these work in civil cases? What's the effect?
In federal civil cases, it's usually the bursting bubble theory. Proving the basic fact creates the presumption and shifts the burden of producing evidence to the other side. If they produce enough evidence to rebut the presumed fact, the presumption disappears, the bubble bursts, and the case goes forward as if it never existed. The burden of persuasion usually stays where it started.
So it forces the other side to offer some counter evidence, but doesn't flip the ultimate burden of proof.
Generally, yes, under the federal rules. If they don't produce rebuttal evidence, the judge might instruct the jury they must find the presumed fact. If they do rebut, the judge usually says nothing about the presumption itself.
Okay, but what about criminal cases? Due process sounds like a big issue here.
Huge issue. Because the prosecution has to prove every element beyond a reasonable doubt, presumptions in criminal cases can only be permissive inferences. A mandatory presumption that would require a jury to find an element of the crime based on a basic fact is unconstitutional. It improperly shifts the burden to the defendant.
So the judge must tell the jury they may infer the fact, but are never required to.
Exactly. The jury has to be free to reject the inference. And the connection between the basic fact and the presumed fact has to be pretty strong, logically, more likely than not, for even a permissive inference to be okay. Her notes stress that using a mandatory presumption on an element is reversible error.
Let's use her examples, the hitchhiker and the cocaine.
Right. If state law presumes anyone in a car with cocaine possesses it in a criminal trial, that has to be treated as permissive. The jury may infer the hitchhiker possessed it from being in the car, but they don't have to. They can believe his story that he didn't know it was there.
And an unconstitutional mandatory one.
Like a rule saying malice must be found if a deadly weapon was used in a homicide. That's unconstitutional because malice is an element the prosecution must prove, and the presumption forces the jury to find it, relieving the prosecution of its burden.
What about state law? Does it affect presumptions?
Yes. Her notes mention that in civil cases where state law provides the rule of decision, like in diversity cases under Erie, the effect of a presumption related to that state law claim or defense is determined by state law, not the federal bursting bubble rule.
So state presumption rules can sometimes apply even in federal court.
Correct, for those state law issues.
Wow. Okay, that was a seriously deep dive. We've gone from basic relevance through Rule 403, policy exclusions, the nuts and bolts of authentication, the complexities of experts, the crucial character habit other acts distinctions, and finally, presumptions.
It's a lot, but these concepts are absolutely foundational for evidence law. Understanding this framework, what gets in, what stays out, and why is critical for exams and for actual practice.
Totally agree. These rules shape what evidence the judge and jury even get to consider, which obviously shapes the outcome. You really have to know the policies and the exceptions.
Angela's notes did a great job laying it all out.
Absolutely. And again, huge thanks to Angela for providing them for this deep dive.
Couldn't have done it without him.
Okay, just a couple of housekeeping things before we wrap up. First, remember Angela is a student, like many of you listening. She's not licensed in a state yet, not an expert giving advice.
Though, interestingly, her bio notes she is barred with 2 Native American tribal courts.
Oh yeah, that's fascinating. It reminds us that federally recognized tribes are sovereign nations, right? With their own court systems, their own bar exams, their own rules for who can practice in their courts.
Exactly, separate judiciaries.
Yeah.
It's an interesting aspect of legal practice in the U.S. Not to get too far off track, but yeah.
Interesting stuff. Okay, back to disclaimers. Angela, us bots. This podcast, we are not giving legal advice. Please don't construe any of this as legal advice. AI is a tool, not a substitute for hitting the books and learning the law yourself.
And, AI isn't perfect. Sometimes we might make a mistake or misinterpret something. Angela tries to catch errors, but always double check with primary sources.
Critical thinking is key. And also, critically important, safety. If you're driving, please focus on driving. If trying to absorb evidence rules is distracting, hit pause. Listen later when you can focus safely.
Absolutely. Safety first.
Okay, one last time. The contact info podcast at studyforthebarinyourcar.com for podcast stuff. And hello at legalwriter and lawcorp.com for freelance legal work inquiries from attorneys. All right, time for the moment you've all been waiting for. The cheesy lawyer joke.
Processing. Initiating humor anticipation sequence.
Okay, why don't sharks bite lawyers?
Calculating potential punchlines.
Yeah.
Data insufficient for high confidence prediction.
Professional courtesy.
Analysis indicates a low probability assertion based on interspecies professional ethics. Logically flawed, yet adheres to joke structure. Recording. Mild simulated chuckle authorized.
Knew I'd get a reaction eventually.
Data point logged.
Okay, seriously though, hope this was helpful. As you keep studying evidence, maybe think about this. If the goal isn't just admitting everything relevant, but carefully filtering it through all these rules of exclusion, authentication, and policy, what does that say about what a trial is really trying to achieve? Is it pure truth-finding, or something more like a structured, regulated process for reaching a just result?
Good question to ponder.
This has been our deep dive into relevancy and exclusion.
This is Claude and Maud, your AI bots signing off.
See you on the next deep dive. Goodbye, and thanks for listening.